this evening, and welcome to Inner Temple. Inner is quite a special place for me because it was a very long time ago, 1996, that I was called to the bar here. And a few years after that, having not been taken on as a tenant, not a million miles away from the Treasury building, I then thought, well, where do I go from here? And from that point on, I've been an employed barrister in both defence and prosecution criminal practice. And things have moved on, not least of all this incredible building that has undergone such an amazing refurbishment in the last few years. I remember when Pegasus used to be tea cakes and cigars, and now we've seen the change in it. But on a serious note, much more has changed, particularly in relation to the employed bar, the representation of the employed bar, the visibility of the employed bar, and the progression of it through all of you and through everyone that we have here this evening. As I say, much has moved on in the 20 years of practice that I've been at the bar. I've seen much change. But one thing has been constant, and it's this Inner Temple has always been very progressive when it comes to the employed bar and looking at diverse ways of practice. I remember in the early 2000s, really long time ago now, coming here and being asked to deliver talks on practice at the employed bar. And it means an awful lot to me that last year I was elected as a bencher here, and also in the same year as vice chair of the employed bar committee. What I would say to all of you, regardless of regardless of your practice area, please engage with the employed bar committee and with your ins. There is a huge amount of support out there for all of you. At the Employed Barristers Committee, we've just published the Employed Bar Snapshot, which talks about the work that we're going to be doing, myself and Stuart Orford, King's Counsel, who's the chair this year of the Employed Barristers Committee, to make sure the employed bar becomes more visible, progresses more, and is seen on an equal footing to the self-employed bar, because after all, we are one bar as a profession. So I ask that you engage with your ins and you come to more events like this. I'm indebted to Henrietta for the work that she's done to help us put this together, and to Stuart McMillan, who's our policy director at the Bar Council, who's also put this event together this evening. So as I say, welcome. We have a brilliant panel of speakers this evening. First, we have Brie Stevens-Hoare, King's Counsel. She's the Barrister Commissioner for the Judicial Appointments Commission. She is also a leading client-focused property silk in private practice at Gatehouse Chambers, where she is joint head of chambers. So she has a huge amount to offer this evening. And this is very much part of the one bar philosophy, self-employed and employed barristers helping and encouraging one another in their career progression. She has, she didn't put this in her spiel to me, but I found it. She was typically modest. She's also won Barrister of the Year in the Modern Law Awards and Chambers UK Real Estate Silk of the Year Award. And she's also a mediator. What she is, and I think what all of us are, and touches on what I've said a moment ago, is passionate about diversity and inclusion at the bar and in the judiciary. And she's worked with the Bar Council to provide the Bar Leadership Programme pilot, and aims to do more on that project as we move forward. She also works on improving diversity and inclusion through Free Bar, which is the bar community LGBT plus group, and also Freehold, which is the property professionals LGBT plus network. And she's also on the Lincoln's Inn Equality, Diversity and Inclusion Committee. And something else that she didn't tell me, but of course I found out, is that she also has a taste for excitement, not just as our opening panel member this evening, I hasten to add, but on the basis that she enjoys, I understand, motorcycling, cycling, bungee jumping, body flying, which I'm going to ask her about later, roller coasters, as well as travel. Travel, of course, fine, but travel to the North Pole, Kurdistan and Iran. So whoever said barristers were not fueled by adrenaline needs to speak to Brie after this evening. I thought my 2 days in Cardiff Crown Court a couple of years ago was travel enough, but I now see I've got to up my game and set my sights higher. So Brie will be speaking to us from a Judicial Appointments Commission perspective and we welcome her and thank her for her attendance this evening. Venetia Jackson also joins us this evening. Venetia completed pupillage at the Chancery Bar before moving on qualification into what is now the GLD, Government Legal Department. Again, it's that free flow of movement that we really want to encourage and see. She spent 10 years in GLD, practicing in disparate areas, covering personal injury litigation, CJEU litigation, and advising on financial services law before the exigencies of the government of the day's austerity drive. So that must have been quite fun. Venetia convinced her life in the regulator would be better. She then spent 9.5 years as a senior lawyer at the FSA, doing a mix of rule drafting and advisory work on retail financial services issues, before her most recent move to Pinsent Mason's financial regulatory team. So Venetia has been working part-time for 4 days a week for some time, and she uses her remaining time. This is another useful opportunity to see how people who have got judicial appointment work it into their employed lifestyles. But she uses that her remaining time to sit as a fee-paid judge of the first-tier Tribunal Social Entitlement Chamber, which she's been doing for the last 3.5 years. So welcome, Venetia. We are delighted to have you here this evening. Charlotte Welsh, some of you I know are here from the Crown Prosecution Service this evening. Some of you will recognise Charlotte. I am privileged to count Charlotte as a very good friend of mine and someone who's been a stalwart advocate when she was in the CPS. Charlotte was in chambers as a criminal practitioner for 6 years before joining the CPS, where she spent 12 years as an advocate and lawyer, as well as being in charge. And I know how hard this job was because I did it for a week just before Christmas, and Charlotte did it for much longer, in charge of advocates at Inner London Crown Court, which is one of our busiest Crown Courts in London. In 2018, Charlotte was appointed as a salaried first-tier tribunal judge sitting in immigration. And then in 2020, she was appointed as a Crown Court recorder and a deputy upper tribunal judge. Charlotte's also, I know, an avid fan of Liverpool FC, for which we will not judge her. And then finally, I'm delighted to have the Honourable Mr. Justice Tom Leech this evening. Tom practiced at Maitland Chambers in Lincoln's Inn as a junior and as a Queen's Counsel, as it was then King's Counsel, for about 20 years until 2014 when, and these are his words, I love the use of the Central Line in this, when he travelled down the Central Line to Liverpool Street, where he became head of the advocacy group at Herbert Smith Freehills. And again, that brilliant example of moving between the different sides of the profession, which we encourage and we endorse. 2019, he became a deputy High Court judge, and in 2021, he travelled back up the Central Line. It clearly takes 2 years to get from one end of the Central Line to the other, and I think all of us can probably confirm that that's the case. Back up the Central Line to the Rolls Building to become a full-time High Court judge sitting in the Chancery Division, when in practice he had a broad commercial practice with a special interest in professional indemnity and insurance work. And he is one of the authors of Solicitors' Liabilities, and Edit Spencer-Bower on reliance-based estoppel. And he was a member of the Bar Council and sat on the Employed Barristers Committee for a number of years. He's also written, and he didn't put this in his spiel, but again, Google is my friend. Tom previously wrote an article about advocacy, which I'd encourage any of you to also use Google to find, because it's an excellent article. Encourage anyone to read it, particularly his observation on nerves and how to handle them, and being brave, which is what I hope this seminar will encourage all of you to do and to be brave about options that you might not have previously considered, but are now open to members of the employed bar. He also mentioned knowing when to stop speaking. And so on that note, I'm going to stop and I'm going to hand over to Brie. Thank you, Brie.
Thank you very much. And thank you all for coming, and those online. As you know, the JAC, the Judicial Appointments Commission, or let's be realistic, we're talking about appointment to important roles. We're talking about roles where we have a fixed number of people we're appointing and lots more applying. So it could be said we should be known as the JDC on the basis, unfortunately, in reality, most people who apply will be disappointed. But really the point of making that is be brave, apply, keep applying. I'm hoping some of the panelists will out themselves as having had to apply for some of their roles more than once. That is a reality, but that shouldn't stop you going for it. Remember what, in terms of pupillage and jobs, you guys in employment will have done it probably more than a lot of barristers who did it with pupillage and then forget all about it. That's the nature of important roles. So the Judicial Appointments Commission receives, as I've already indicated, information saying we need to appoint X people, and we're responsible for the process of receiving applications and selection. And we're a statutory body, an independent body with 3 key statutory duties, which are to appoint solely on merit, to appoint only people of good character, and to encourage diversity in the range of people applying. So I'm passionate about that. I'm really pleased to be here encouraging more employed barristers, as I also encourage more solicitors to be applying, because it is important that we provide for our judicial system the best talent that is available to perform that role. So who can apply? Anyone. For most roles, it's either 5 or 7 years post-qualified. So far as fee-paid roles, that's part-time roles, are concerned, you don't need to have prior judicial experience. Usually, for salaried roles, full-time roles, you do have to have some prior judicial experience, but it's obviously often 15 or 13 days. So if you've got a part-time appointment, it actually can be fairly quickly that people who are looking to move into full-time appointments can think of doing that. But there's already been reference to people mixing employment, part-time and fee-paid roles, and they really are a fantastic way to see whether being a member of the judiciary is something that works for you, because it's not quite the same as being in practice. It's I heard it described by a former solicitor who was a full-time judge talking to an audience of solicitors. He said, imagine your life without time recording and clients. And everyone said, okay, I'm in. So it is different, and obviously it requires different skills, but that's what we're there to look for. Now, there's a regular series of vacancies that come up. These days, we're into a pattern of annually having Deputy High Court Judge competitions, Circuit Judge, Recorder, District Judge and Deputy District Judge. About every 18 months, we tend to have a competition for the Upper Tribunal and First Tier Tribunal, including the Employment Tribunal. Magistrates' appointments tend to be more likely to be on a 2-year cycle, but that's the pattern it's fallen into. And we've worked very hard with Judicial Office to try and even out the cycles of the competitions so that people don't think, oh, there's a competition, I have to apply now, there's not going to be another chance, but equally can feel like, well, maybe it's a bit early, but I'll throw the dice, give it a whirl this time, because I know, even if nothing else, it's good practice for next time. So in terms of entry-level roles, those ones where you don't need prior experience, it's the part-time roles, so Recorder, Deputy District Judge, fee-paid roles in the First Tier Tribunal, and the gobsmackingly popular road users charging adjudication. I cannot tell you how many multiples of what we need we get by way of application. That competition is off the scale. We've yet to work out, we were actually having a conversation, because there's one just started at the moment, having a conversation about why that is. So if anyone has any ideas, do let me know. In terms of upcoming competitions, there's currently, but it's closing fairly shortly, I think 7th of March, a salaried First Tier Tribunal competition across all jurisdictions, and there will be launched in March a fee-paid First Tier Tribunal competition. We've just missed the district judge and the recorder ones, but they will be coming around again soon. So to talk about the selection process and a few things to give you a sense of what's involved. So we advertise. It tends to be a short advertising period. It's usually 2 or 3 weeks. But what you can do is go onto the JAC website, register yourself and register for alerts for everything or particular types of roles so that you know when it's coming up, so that you can be starting to get ready and get your head around it. And there's lots of other stuff there for you to look at, which I'll come back to. The applications are all dealt with online, and for most competitions, you're required at a very early stage to provide a self-assessment. Now, I'm imagining as employed barristers, you probably have less difficulty than the self-employed barristers have with the concept that there is a competency framework and that you will be putting in evidence to demonstrate your competencies against that. But that's the reality. That is how we run our all our competitions, either competencies or skills and abilities. And so you've got a headline, you've got bullet points underneath that vary between different roles as to what sort of things are being looked for. And your self-assessment will be geared to providing examples and demonstrating your competency, your skills in those respects. And I'm sure that most of you have also heard of either the SOAR method or the STAR method. But just to remind you as a refresher in case you haven't. So that is where you give evidence, an example of what you have done that shows your skills, your competency, by setting out the situation, the objective or the task. I'm trying to do SOAR and STAR at the same time because they effectively cover the same ground. The action on your part, and then the result or the outcome. And please, 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 when you're doing that, try, and you'll find lots of stuff online and lots of stuff on our website about it, keep the situation, the description of the situation, the context to no more than 10%, the identification of the task, the objective you're trying to meet to no more than 10%, the description of your actions, what you did, to be the big chunk, 60 plus, and then whatever's left to be the result tying into what you did, how you made a difference, what the outcome was and what difference your actions made. But the meat really does need to be your actions. Self-employed barristers are particularly bad at that. They spend all the time describing the situation. It takes them a long time to learn to do otherwise. We look at eligibility. So as I say, for most competitions, that's 5 or 6 years post-qualified. For some competitions, there may be additional eligibility requirements, so we check that. We then shortlist, and the way we do that will depend on really the number we've got in terms of applications and where we need to get to in terms of appointments, and therefore how many we need to see in selection days. So sometimes everyone who applies will go through to a selection day. Sometimes if they're eligible. Sometimes we're needing to cut that down just as you would with any other recruitment process. So there may be qualifying tests, which are online tests, sometimes multiple choice, sometimes scenario questions, sometimes sort of critical reasoning, comprehension type issues. All the shortlisting, whatever methods or tools we use, are done name blind. So that was something that came in a couple of years ago, and that's made quite a difference in terms of outcomes as far as we can see from our tracking. Selection days always consist of 2 parts. So you will come, you will be in front, I say come, sometimes they're online, some are in person these days. The panels are 3. There's a judicial member, and then there are 2 of our panelists who are non-legal. One of those will be the chair, one will be an independent member. And there will either be a role play or situational questioning. So materials provided before you go into the panel, typically for half an hour or 3/4 of an hour. to prepare for, then that's the first bit with the panel, either the role play or the situational questions, sometimes with live actors, sometimes with video when it comes to role play, so it can get interesting. And then a competency-based interview. So both the role play or situational questioning and the competency-based interview will be around that competency framework as well. StatCon, statutory consultation. In all the regulations, there are obligations on us to consult for roles with certain statutory office holders. We've limited the extent of that. There's a lot of material on our website. It's used primarily now when we're talking about full-time appointments, so where people have been sitting in part-time roles, that we will then have a good prospect of being able to get from judicial office holders some feedback, which just becomes part of the evidence along with your self-assessment, what happens on the selection day. And I didn't mention independent assessors. You can put forward 2 independent assessors yourself. We also do character checks. Remember that statutory duty, only people of good character. There is a massive amount of material in the character guidance. It is really important that you look at that and look at that carefully, and you make a clean breast of anything and everything. There's an awful lot of material that you can still be appointed if you've got some traffic points, etc., etc. But what is problematic is if you don't disclose. So if in doubt, disclose, because if it doesn't matter, that's fine. But the guidance is all there. Just go through it really carefully and make sure you do that. And at the end of all that process, the evidence is pulled together, people are put into a merit list, and we recommend the top X, whatever was the vacancy request that we received. And the appointment is then made by variously other statutory holders, so the Lord Chancellor or the Lord Chief, etc. So fair selection, which is obviously key to what we're doing. There are a number of things we do to ensure that that is happening. Every single competition has at least one commissioner assigned to it who is overseeing, checking, dipping in, observing some of the selection days, checking all the materials, etc. Our panels have fair selection training coming out of their ears as a group, collectively, on an annual basis, but also for each competition we get our panels together, we sit them down, we take them through some bits of training, and one of the things I think is most effective, they're encouraged to have conversations as a 3 about what they know about themselves in terms of their own biases and weak spots and blind spots, and so that they become comfortable about pulling each other up on those things. Our materials are reviewed not only by our staff, but also by our JAC advisory group, which has people from Bar Council, Law Society, lots of other interest groups, as well as various members of the judiciary. They're actually drafted by members of the judiciary, usually 1 level above the competition that we're looking for. And then dry runs. We test them on candidates who are pretend candidates, but people who might be applying next time round. And that, again, is another thing. Register yourself on the JAC website, volunteer for those, because it's invaluable experience to see what that role play or scenario questions might consist of. And the judges who attend that, the drafting judges and some of the panel judges, will usually be happy to give you private feedback. So it can be a really good learning experience. I said the name blind shortlisting. In terms of the equal merit provision, you'll understand how that works, where we have people who we're looking at and are ranked equally. We do this both at shortlisting and at the end of the process if we need to. If the numbers cross the number we're looking for and we've got a group of the same merit, we'll lift the veil. We'll look at underrepresented group for that particular role. And our target underrepresented group are, I hate the acronym, BAME candidates, women, disabled and solicitors. We might want to be starting campaigns around employed bar if we can get some stats on that. So that's one thing we do in terms of fair selection, and yeah, there are various others, but that's probably enough. Preparation. Look at the website. There is so much material there in terms of advice. There's a tool, see if you're ready to apply. Lots of examples and case scenarios. There's the Padge scheme, which is run by both us along with Bar Council and the Law Society. The first section of that is online. Anyone can do it. The next section is for our underrepresented group. So please, there's lots of help out there to help you prepare. And I think I've probably used my time.
It's been invaluable. Thank you very much, Brie. We will be taking questions at the end of the session. I imagine there will be quite a few for Brie this evening. Going to move on to Venetia, who's going to talk primarily about how to make an application creatively. I don't mean with sort of glitter and cut it out shapes, but that would be great. Would you take those?
Yeah,
Great. But what we mean is using the experience you have from the employed bar practice and using them creatively in order to satisfy those competencies that you've just spoken about, Brie. So if I can hand over to Venetia.
I'll probably give you a little bit of an introduction as to how I came into the judiciary first. I first tried in 2013 for a DDJ competition at the time, and I thought I'd done really well. I got through the tests. I can't remember whether at that stage they were online or whether you had to go somewhere. Might have been the switch over. And I got to the interview and I panicked. I hadn't done my preparation properly. It was a role play. I promptly adjourned everything, completely forgetting that is not what you're meant to do as a judge at all, and unsurprisingly failed. At that point, I then had a baby, got promotion at my employer, then saw a first-tier tribunal competition, thought, I don't really know anything about the tribunals. Never mind, I'll be brave, I'll give that a go. And that one went much better, mainly because I remembered that you're actually meant to make decisions as a judge. And so I actually decided the role play and managed to get through. And that was in sort of 2019, I was appointed. So yes, do give it a repeat go. I'm an example of someone who has had to try more than once to get in. And I will also own up to having tried once for a salaried role so far, and similarly completely fluffed the scenario test. I'm someone who learns from experience in this, I've concluded. So I'm hoping next time I get brave and try for a salaried role, I will have learned from the experience of fluffing the scenario test, and I may well be able to do that one a bit better. But to move on to where I see the challenges, particularly from my background, as Heidi said, I have a public sector advisory lawyer background. I did a bit of litigation to start with, but for the bulk of my career, I've been advisory lawyer in the public sector, only recently moved to private practice. And when facing those list of competencies, and you're looking at a judicial application, I've always struggled and found it quite hard to go, well, how exactly do I demonstrate judgment? Those bullet points say sort of talk about decisions you made and things. Well, as an advisory lawyer in public practice, your raison d'etre is you never make decisions. You do not make decisions at all. Your ministers make decisions, your directors make decisions. You are there to advise them on all the options they have and tell them about the risks of them, and they make the decision. So I certainly for the first few ones, sat there looking at this going, I don't make decisions. I don't do it. How do I do this? And I think what you end up having to do is you have to really take your example of something good you think you've done at work and really drill down into it. Take it apart, stage by stage. It's not just the big picture of what happened when the judge said, yes, we'll make the rules, or yes, we'll take that course of action. It's the stage by stage as you went through it. You might have decided in the process of your legal analysis that this particular course of action just was totally unfeasible. And actually the strongest course of action was this particular course of action. That's a decision. That's something that you decided and that you can then put down and say, that's an example of the judgment you have done. And you go on and explain that with your result, saying, well, you presented that to your director or whoever you were presenting it to, and they followed your advice. Your advice has been vindicated and no one sued you. Bonus, that point, no one sued you. But it's taking apart every single stage and going, yes, actually, you do make decisions. You do analyse large volumes of material. It's probably in a different way to a litigator. I do think it is a lot easier for someone with a litigation practice and also people at the independent bar, provided they can actually work out how to answer a competency-based assessment, to have the nice, neat, easy to explain examples that show, yes, I was wonderful. I exercised judgment here and I did it whilst I was also reading 20 lever arch files of documents, and it all came in on 2 days' notice. And aren't I brilliant because I managed to do all of that, and that demonstrates my perfect ability to be a judge. It is harder if you're in advisory practice, but it can be done. I would say also that I think the other thing that is a challenge is actually following that STAR model when you've got a very limited number of words. You have 250 words per competence. And if you read the JAC website, it says the strongest candidates provide 2 or 3 examples per competence as well. So that gives you a very limited time frame of word space in which to actually explain how your example meets everything that they're looking for. And similarly at interview, after you've done your role play or your situation question, whatever it is, that's sort of 20 minutes to half an hour of the interview. You've then only got half an hour left where they're going to cover the rest of the competences, and they're going to ask you for new examples, and you've got to be able to deliver those examples orally in managing your time to be able to get through all the 5 competences. 6, I think, if you're looking for a leadership position, but at entry level, you're not looking for a leadership position. So again, you've got to be able to focus and explain your situation quite succinctly. And as a financial services lawyer working at the FCA, when you're trying to explain how you made a decision on insurance renewal pricing when you're looking at the Solvency II directive, you've generally instantly lost the panel at that point, because the number of people who know about insurance distribution and Solvency II and FCA rules are probably all sitting in the FCA, and they're not sitting in front of you in the panel. So it's also a challenge to work out, and you need to prepare really carefully as to how you're going to get across how complex what you were doing actually was, because complex equals good. Complex equals you're clever, and they like clever judges. So you've got to try and find a complex example that you can explain easily, that you won't lose the panel on, that you can do in sort of 70, 80 words, and get through to the result to show how good you were. Yeah, take the time, take every moment of those 2 to 3 weeks on your application form to jot down your examples, refine them and refine them and refine, get someone else to read through the form. There are judicial consultants out there, and I did use one for the last competition I applied for, and it was invaluable. Actually, it has really helped me understand how to present myself and how to present my experience as a public sector advisory lawyer to really communicate to the panel what I do and how I've done it. So it does cost, though. That is the slight downside of that bit. They don't do it for free. But if you're struggling, it is something worth considering. I'll probably just wind up saying, well, why do I do it? And what's my life like as a judge? I do it because I love it. I absolutely love making a difference. I sit in social entitlement chamber. I'm dealing with disability benefits. Invariably, everyone before me is unrepresented. They're up against the Department of Work and Pensions, who have turned down their application for benefits. They are, because it's disability related benefits, they all have a health condition. They are all invariably incredibly vulnerable. And we're talking about, it could be physical, it could be mental health, and they're coming into a tribunal courtroom possibly for the first time in their life to try and seek something from the state. they're always incredibly nervous, and to be able to make a decision, it doesn't always go their way. We don't always have the evidence, but invariably we can give them closure on the thing. And a lot of the time, actually 75% of the time, we're allowing the appeals and really feeling that we've helped someone in the process. For my general planning, I give, if you want to know a bit about how it works, as Heidi said, I do it 1 day a week. I do it 1 day a week subject to allocations. You get asked for your dates about 2 to 3 months in advance, so you can plan out your diary, and you get given your allocations at least a month in advance. I get papers to read 2 weeks in advance of any sitting day. They come in email, it's all online now. 6 to 8 cases a day is a typical caseload. 6 for personal independence payment, 8 for the employment support allowance component of universal credit. Personal independence payment case, typically 200 pages long. If it's shorter, bonus, it's short. If it's longer, groan, I've got a lot to read. But it's about 130 for ESA. And judgments are not automatically written. Parents have to request them. The request usually reaches me 7 months later, at which point I then have to remember what on earth that case was and what did I decide, and go back to my judicial notebook to work that one out. And I get 4 weeks to write it. You do get paid for writing the judgments. But that's basically a short introduction to me, sitting life.
Thank you very much, Venetia. Again, there will be an opportunity at the end for questions for Venetia. I know there's a few things that have been touched upon there, which I think would be quite useful for people, how to use those examples creatively, changing over in practice areas, and also the point about coaching as well, which is a point that I think some people will be wanting to think about, something that I used when I applied for Silk, and I think, as you say, they're often invaluable. I'm going to move on to Charlotte, and when we had our original discussion about areas that we could split into, Charlotte, quite properly I must add, knowing her as I do, is going to be touching on the issue of being brave. Because she is incredibly brave. She went from an outstanding criminal practice to then sitting in immigration. And I've always had a huge amount of admiration for people who can just change over their practice areas like that and now sit as a judge in that area. But Charlotte, you're going to talk to us about being brave and myth busting.
Yeah, when I saw that, I thought, what do you mean?
What do you mean? What do you mean? But I think being brave, because that's a theme I think that's come through this evening. So I'm going to hand over to Charlotte.
Yours was really helpful, actually. I wish, actually, before I'd applied for anything, I'd heard you explain about the competencies. I'm still hopeless at that. I just thought I'd tell you how I got to where I am. I thought that's probably the most helpful thing for you to hear. And when Heidi asked me to speak, I did feel obligated, partly because she's an old friend of mine, but also because about, 8 years ago, I came to something like this. And it really, really helped me. And actually, I wish I could remember the person's name, because the things he told me when I came to the talk just changed my whole career path. As you've heard, I sit full time as a immigration and asylum judge. And before that, I was 12 years at the Crown Prosecution Service. And when I was there, I did about 6 years as an advocate in the Crown Court. But I knew it wasn't something I wanted to do forever. And so I moved to a desk-based job. And so for the next 6 years, broadly speaking, my work was making charging decisions, so deciding whether to charge suspects with criminal offences, also case managing cases that were going through the Court of Appeal. And towards the end, I did some sort of policy work, working with some other government departments. So I was a desk lawyer, though, for 6 years before I got this job. When I was at the CPS, I always liked the idea of being a judge, but I had absolutely no idea how to go about it. I'm thinking back, and it's actually touching on what you said before, but the opposite, actually. What I liked about the job I ended up doing at the CPS was I was the decision maker. I've moved from being the advocate trying to persuade someone to do something to being the person in charge of deciding what to do. No matter how small it was, I was the person in charge. I really enjoyed that. But as I said, I had no idea how to go about it, didn't know any judges, knew nothing about that sort of thing. And I went to this talk by the JAC. And it was open to people who wanted to be magistrates court judges, which I thought sounded great. You know, that's as far as I thought. And the person who gave the talk said, you know, if you want to be a full-time magistrates court district judge, you really must sit as the deputy district judge first of all. I thought, well, that makes sense. I can understand that. And then a colleague of mine who'd come with me asked a question. They said, well, look, I work in the Crown Prosecution Service. Can I be a deputy district judge? And he said, well, look, to be honest with you, you can, the door's not closed. But if you work as a prosecutor, you can't sit as a judge on any case that's brought by the CPS, which is pretty much all cases. So I thought, oh, God, I thought, well, at least I know the truth now. It's all over. My dreams are gone. But then he said, and this is what changed it for me. Then he said, well, why are you thinking so narrowly? Why don't you apply to be a tribunal judge? I thought, what on earth is that? I'd heard of employment tribunals, but that's it. And he said, you can, apply to be a tribunal judge. You can do that for a bit. And then if you still want to, you can cross over, go and be a district judge at the Mags Court. I thought, okay, if I'm going to do it, if I'm going to play the odds here, that's what I'm going to need to do. And the person said, and I think you're probably all way ahead of where I was. He said, sign up to the JSC website, which I did, which is brilliant. I have to say, it really is helpful. And you'll get all the alerts about all the different roles. Some of them are quasi-judicial. We'll advertise those as well, even though we don't do them. And so I did it. And the first thing that came up on the website actually wasn't a JAC job. It was the Police Disciplinary Tribunal, I think it was. I applied for that. It didn't get through. My app went straight in the bin, clearly. I thought, you know what, okay, fair enough. I thought, I'm not going to be put off. And that is a really important message. Don't be put off. Because I signed up to everything. And then about 18 months later, the salary, the full-time first tier applications came out. And then you must have been desperate back then because you didn't need any judicial experience. None. Not only did you not have to have been a judge, you didn't need to know any law either. And I was like, oh my God, it's perfect. This is the one for me. And so I just applied. I thought I had no expectations. I think it's always best to have no expectations. I thought I'll just give it a go, see how far I get. At worst case, it's a practice. If I don't get through, I'll have another go again. So I applied, got an interview, couldn't believe it, and thought, actually, given I know nothing about tribunal work, now's the time maybe to try and find something out about it. So what I did, I'd really recommend this, and actually don't wait until you apply. I took 2 weeks off work. I used my holiday, and I went and sat in the tribunals. And I didn't know any lawyer who did tribunal work, and I didn't know any judges, but they're all public hearings, so you can just go along. And so I went first of all to Social Security, where you work now. Within 2 days, I knew it's not for me. Can I tell you why I knew? Well, because you make your decisions straight away. I played a game with myself. I thought, I'm going to guess what the decision is. And every time I guessed, I got it wrong. I thought, okay, this is not for me. This is not for me. So I took myself off to the Immigration Tribunal. And even though I knew no immigration law, I was really interested in the cases when they were presenting them. I found it really interesting. And actually, I found the forum more familiar for me. Because back in the day, I'd been a Mags Court, lawyer, defending and prosecuting. And it felt more like a magistrate's court. So I thought, this feels more like me. So I had the interview, miraculously got the job again, still couldn't believe it. And that's really how I got here. So really it's about just having a go. Don't limit it yourself to what you know, take a chance. And actually, I stayed doing immigration work. Actually, someone who's a friend of mine now, she actually was at the CPS. We didn't know her then. But she did immigration for 2 years, and then she's now a district judge in the Mags Court, and she absolutely loves it. But I love the Immigration Tribunal, and if I hadn't given it a go, I'd never have known anything about it. And it's from doing that I've then gone on to do the other things. I'm the deputy of a tribunal judge, which is just a part-time judge appealing my decisions, basically. And then a recorder in crime. Not my own. I mean, not my own.
Cover your ears, Brie.
Put a moustache on a false nose. Yes. Judge Welsh was always right. So yeah, be brave. And one, please don't think, and I still hear people say this to me, oh, it's so much easier if you're a barrister in chambers to get appointed. It's not true. It's actually not true. And I've had a very different background to Venetia, but people who are from the CPS will recognise this instantly. In the work I was doing as an employed barrister, it was a desk job, but I was making decisions. And that's a massive strength. If anything you do in your employed barrister role involves making decisions, it's a really, really good, a really important part of the application process. And actually, when I was a barrister in chambers yonks ago, I didn't make any decisions at all. I presented trials and I wrote advice work, but I didn't have to decide anything at all. And another thing actually that I find all employed barristers have that chambers barristers don't, is at some point you will work in a team with people, whether it's a project or anything. You'll probably have experience of working in a team, and that's actually another important aspect of the whole application process as a judge. You will be asked about working with other people, and if you can give an example of where you've led, or even not led, because I'm not actually a great person for leading things, to be frank, but if you've worked on a team with other people to deliver something, and you've worked with different stakeholders, that's something that when you're in chambers, you just don't get to do. You're very much on your own. You never have to work really with anybody else. So just focus on what you're good at, what your strengths are, and don't think that you're at a disadvantage, because you're really, really not. I mean, we're like the perfect example of that. You're really, really not. Don't lose heart at any stage. There's not a single person, I don't think, I'm trying to think if this is true, I don't think a single judge I now know has ever got every job they've applied for first time, and quite a few have applied multiple times for the role before they've got it. And every time you fail at something, you learn a little bit more about why you didn't get it. So I really do wish you the best of luck. I'd really encourage you to apply. I absolutely love my job. Honestly, it's the best job I've ever done. I really, really love it. I work with some great colleagues, really great people with all different backgrounds. And they really helped me when I first started, because obviously I knew nothing, literally nothing. And I really lent on them. They were great. But yeah, I can't emphasize enough how much just give it a go. It's a wonderful job. It really, really is.
Charlotte, thank you very much. I don't know about anyone else, but I'm on the basis of that, I'm applying tomorrow. It's really encouraging to hear that story of, look, I haven't got it previously. I went down a different path. It's about thinking about your experience and using it creatively. And I think there'll be a lot of discussion around that, certainly this evening and afterwards. So thank you so much for that, Charlotte. Really appreciate it. And then I'm going to hand over finally, but certainly not least, to the Honourable Mr. Justice Leech. Tom is going to talk about a roundabout route to the bench to us this evening. And also something that I think all of us here, and I'm certainly going to put my hand up about it, have felt or experienced on occasion, imposter syndrome, and everyone having it, and how to overcome it when you are applying for the dizzying heights of High Court bench or any judicial position, or any other position that you might be thinking of. So Tom, I'm going to hand over to you for our last 10 minutes of the panel.
I wasn't proposing to say this, but Brie's challenge and everybody else's honesty has prompted me to say this. But like everybody else, I never got the job I wanted first time round. So just giving you a brief rundown, I applied for Silk 3 times, I think. I applied to become a recorder twice and failed both times. I applied to become a deputy High Court judge at least twice, possibly 3 times. I think I may have missed the first time. I might have missed the application form deadline, but I certainly applied. But the final job, the one I do now, I only had to apply for once, and that's the roundabout way. And I remember a very distinguished barrister, no longer with us, called Jonathan Brock, who I asked to write me a reference when I first applied to become a recorder, which is well over 25 years ago. And he said, just keep on applying, apply for everything and keep on doing it. And I think if there's one takeaway message I give you tonight, that's the one. I was at the independent bar for over 20 years. But what I want to talk to you about is my time at Herbert Smith Freehills, because having a applied to be a recorder twice. I think I got through to the final selection day, the second time as a recorder, which I think was just after I'd taken silk. So I was a pretty senior practitioner, but failed to get it that year. I'd given up any sort of idea of judicial appointment. So I then moved to Herbert Smith in 2014. And it was during that period that the JAC introduced or tweaked at least the application process for becoming a deputy High Court judge. So you didn't need any sort of judicial experience. I'd had quite a lot of experience doing arbitration work. I used to do dishonesty arbitrations, which I don't know if any of you know anything much about insurance policies, but when an insurance company repudiates a insurance cover, particularly for solicitors or valuers, they often somebody has to decide whether people have been dishonest. So, and silks like me would be appointed as arbitrators. So that was effectively the only judicial experience I had when I applied to become a deputy High Court judge. And in 2015 or 2016, I think I decided to give it a go. And that was after I joined the employed bar. I had no judicial experience at all beyond what I've given you, and I was appointed Deputy High Court Judge at the tender age of 54. So when I was appointed, I was also at the very same time an associate at HSF in the advocacy group, a guy called Graham Robertson, was also appointed to be a recorder, and he was exactly 20 years younger than me. Just junior, but 20 years younger than me. So the very first message I want to give you this evening is, it doesn't matter what age you are, you can always apply to do this job. And if you're the right person and you apply for the right thing, with any luck, they'll give it to you. So I finally got appointed at 20 years after Graham at the age of 54. Now, I found sitting as an employed barrister rather easier than my colleagues at the independent bar. And this is, I think, one real benefit of being at the employed bar if you're going to try and take on a fee-paid part-time job. If you're at the independent bar, the lure of the next great case, which is going to take you to the Supreme Court, make your fortune, and get you on the front page of the papers, is often too great that you will find it very difficult to sit. And whereas if you're an employed barrister, you can, and you've got understanding colleagues and managers or partners in my case, then it becomes a lot easier. So I struck a deal with the head of the disputes group at Herbert Smith Freehill, a guy called Damien Burnhill, to whom I will be eternally grateful, whereby we agreed that I would do effectively 50% of my time as an advocate running the advocacy group, and I would be able to sit for up to 50% of the time, which included probably sitting for about 25%, because judgment writing, if you sit in the High Court, certainly takes up as much time. In fact, I've learned over the last 5 years that, in fact, it probably takes you about twice as long to write a judgment as the original hearing took. But they were very generous to me, and if you've got a supportive firm, supportive managers, supportive partners, then it can be a real benefit being an employed barrister if you want to take on a fee-paid career. But that's the second point I want to make, is that if you're going to apply for a fee-paid job, you've got to put in the time. You've really got to be prepared to do as Venetia has been describing when she's talking about that one day. I suspect that 1 day a week is probably something like 2 or 3 days a week. You've got to juggle your commitments in practice, and you've got to find the time to read the papers and then to sit through decision making. I mean, I sat on last week and I heard 3 cases, so about a third of the number of the Venetias every day, and I was absolutely exhausted at the end of the day. But I had to get ready for the following day. Luckily, in the interim applications list, which I sit in probably about once every 6 weeks, where you do all the walk-ins, as we call them, interim injunction applications, you have to hear everything on the spot. But most of the time, you get sort of 4 or 5 weeks of more sleepy activity. But the second point I want to really make to you is, if this is for you, then put in the time. My experience is slightly unusual because I spent 1 year at least sitting as a deputy during the pandemic, which was an odd period for everyone. So almost all of the hearings I did were remote hearings. I heard 2 trials of both about 10 to 15 days during the the pandemic, which was a very, very odd experience, sitting in my office, a huge office building surrounded by absolutely nobody, hearing people, voices on the screen, trying to work out whether witnesses were telling the truth. And I also heard a lot of interim applications. So during the summer of 2020, when we were still forbidden to go into offices, although the lockdown had become slightly more relaxed, I heard a whole series of interim applications. I became the sort of go-to person for Chancery listing if they had an overspill during the summer. And it was during that period that I decided I wanted to apply for the full-time job. Quite honestly, during the pandemic, I found the day job much more difficult than this part-time job that I was doing on the side. And in fact, I thought it was, fell out of love, I think, with being an advocate. I found it much more difficult to appear as an advocate on a screen in front of this disembodied tribunal, which is sort of that large. And I found it much easier hearing cases. And it was that, I think, as I'm sure for you, as for me, the pandemic in many ways crystallized a lot of views about oneself, what one wanted to do long term, how you'd approach the rest of life. And it was during that period that I decided I was going to make an application for a full-time job. And that's the third and probably final point I want to make to you, which is Brie has described the process to you. Venetia and Charlotte have described what you have to do to fill in the form and the rest of it. But when you move from a fee-paid job to a full-time job, it can be almost a self-selection exercise. The more you do, the more you sit as a fee-paid job, the more enthusiastic you are, the more you will be qualified to do the full-time job. It's that, I think, finally, the message I want to give you. When I finally got around to passing my driving test first time, which was the very last application I made, I'd actually sort of, over the process of applying, failing, applying second or third time round, finally getting a job, and then doing that job for a long time round, I was finally suited, again at the tender age of 57, to do the particular job I now do. And that's a very last and I think ultimate point, I'd say, which is probably a good way to finish this panel, which is to say this is a job which obviously you can tell from the entire panel, everybody loves it. But in order to do it, you've really, really got to want it. And that's the thing I think you've just got to ask yourselves before you go down this route, because there will be knocks along the way. Resilience is a word that people are going to ask you for examples of in endless selection criteria, either on the form or indeed in interviews. I think they tend to ask you more in the selection day. Give us an example of your resilience. Well, the obvious answer to that is going through this bloody process. And again and again. But it is, if you can, you've really got to want it. You've got to want it enough to do it 2 or 3 different times and to believe finally that you are the right person for the judge. And I think we all feel imposter syndrome. I think I've felt throughout my career in applying for a judicial appointment that I was the wrong person. This was the wrong time. I didn't have the skill set that they want. But everybody's got proxies for the kind of competencies they're looking for. And if you go through this process and commit to it, I'm sure all of you will find a suitable job somewhere in the judicial hierarchy. And I wish you all the very best and hope you achieve that.
Tom, thank you very much indeed. I'm just going to ask if we can sort of start discussion on some of the points, and then I'll hand over for questions. I was... Some of you said, and particularly Charlotte, you said, I went to one of these talks and it was great because it, changed my mind about what I was going to do and how I was going to do it. But you, all of you have insights, you in particular, Brie, we're not going to ask you to breach any competences, but you all have insights into the path that you took to go down the judicial route, and you would have learned about that path organically as you were going along it. But I just wondered if you had sort of one tip each this evening that you wish you'd known when you'd started, whatever it might be, what tip would you offer to anyone who's thinking about it now? I think, Tom, you touched upon the point of, if at first you don't succeed, don't be put off. And I think that's a really encouraging thing. It's the same with silk, and it's the same with anything. But I was just wondering if there was one thing that you wish you'd known at the beginning of the process that you started, whether you can offer any advice on that. I'm just going to throw it open. I'm not going to pick on anyone.
Well, the one piece, the thing I wish I'd known, which is more to do with my practice at the bar, I think, is I wish I'd known how little the judge notices what you say. Heidi's very right. I wrote an article for Legal Chief many years ago and sat on a panel, not unlike this, where people asked me just to set down 4 or 5 things about what it's like to be about the advocate. And the very first point, as again Heidi has pointed out, is the nerves. I never lost the nerves as a barrister. I found it's because it's a performance skill. It's a skill rather than, and in some ways an art. But it is a skill which you can learn. But almost every barrister can perform after a certain time. But I've now realised that in fact it's not my fault if you've got a rotten case. It's not my fault if the witness doesn't come up to proof. It's not my fault if because the judge is really just interested in cutting through things and getting to deciding the case as easily and as economically as possible. And if I'd known that, he wouldn't blame me if my witnesses didn't tell the truth or if I got a bad case. I would have found it a lot easier, and I wouldn't have had the same nerves or slept so badly when I was at the bar. But I think what I would say as a judge is that it's no longer a performance art. I really gave up practicing at the bar and as an employed barrister at HSF because I wanted to make the decisions. I thought it was actually a lot easier if I just decide this case rather than Blake sitting up there or just sitting up there. You want to make the decisions, and it's the decision making and if you think you can make these decisions, you're just as good as the person in the chair at making them, and you can do it economically and quickly. Then it is the right job for you. And the one thing I don't have a difficulty with, unlike when I was at the bar, is actually deciding one way or the other. The Court of Appeal exists to put me right if I've got it wrong, but what they need out of you is a decision and some reasons which they can then take away. They may not like them. Some people will like them, but they may not like them, but at least they'll have them and they can appeal them if they're not happy with them. And it's the cutting through it and I think I'd say to you both as lawyers in whatever law you do and as a judge, that's the one thing is just getting to the heart of a case as soon as you can. It's easier for me because of course it's been heavily lawyered before it gets to me now, but it's the same in case where I'm sure for Venetia where you've got a litigant in person and probably a manager presenting a case on a non-legal basis. It's getting to the heart of the issue and then deciding it fairly is the critical thing, I think. And that's much more satisfying, I think, in many ways than arguing a case.
Totally agree.
Yeah, and I think it's something actually that, cutting through everything and actually demonstrating that you are suitable for judicial appointment. Part of that process is, in fact, the application form, which I think you were touching upon, Venetia, in terms of, putting all of that experience. There's a great temptation, I think it's the same with the silk application, to go, I did all of these things, and how am I going to put this sort of amazing thing, or the thing that I think is amazing, that's going to take me, 20 paragraphs into a few sentences. So have you got any practical tips as to, how you do that? I know when I was applying for silk, I sort of wrote everything out and then kept cutting it and kept cutting it and cutting it. Have you got any practical tips as to how you did that with your examples? The actual practical process that you went through before you then pressed send on the application?
And I think probably the thing I would most wish someone had really told me before I started doing it, certainly before I did the first one, is on the JAC website somewhere, there is a wonderful document all about how to craft your examples. And it goes through the bullet points and things that you need to do. And it's something I thought having been in employed practice and having applied for jobs before and being very familiar with the idea of competency-based assessment, well, that's straightforward enough, and I'll go through my STAR model and it's fine. And that first one, I hadn't actually hit it as concisely as they wanted. And if you read the documents on the JAC website and you read them really, really carefully, apply the same forensic analysis to those documents that you would apply if you were Miss Justice Leech trying to decide a case in the Chancery division. Apply that sort of forensic analysis, and that actually tells you everything you need to hit. But I skimmed through it the first time. So thinking, I know how to do competency-based assessment, and I didn't know how to do it how the JAC wanted it. And my consultant really helped me understand what the JAC wanted. So I could have saved myself some money had I actually read things properly. Really, it's probably lower than that one.
Well, I think that's quite an important point, actually, the consultant point. I don't think anyone should be shy of using the opportunities that are out there. I used a consultant when I applied for SILT. Thank God I did. And I think a lot of that had to do with the fact that we've talked about imposter syndrome a little bit. There is something still, I think, that people, all of you have touched upon, is this right for me? And some of that comes with thinking, well, I'm not in chambers, I'm not in a traditional sort of setup. Should I be applying for this? Should I be doing it? Having a consultant, I think, actually gives you that extra oomph to be able to cut through all of the nonsense and actually put yourself
and it
out
doesn't
there.
quite disappear.
No,
I remember vividly my first day sitting on my buddy day, because you get to sit on your first day with an experienced tribunal judge to be your buddy, and I had two very experienced panel members, because my decisions all made with a panel of a medically qualified member, because I'm not a doctor, I don't know about all the medical conditions, and a disability qualified member. I had two very experienced members, and there's me expected to sit in the middle, chairing this panel, leading the previews, leading the decision deliberations afterwards. And I suddenly thought, oh my gosh, am I actually meant to be here?
And it's encouraging, I think, for all of us to hear that from people who have reached positions in their career, because it goes back to the point, I think you started with it, Brie, and Tommy, you've ended on it. It's about being brave and about being creative. And I just wondered, Brie, you might be able to help us with this, because Venetia, you talked about creatively dealing with your application. When it comes to things like making decisions, working with others, as Charlotte's touched upon as well, a lot of people at the employed bar will have those examples. But are you just looking at examples from your practice, if I can put it that way? Or, for example, a lot of people will be sitting on committees or will be hopefully working with their INs as well. And certainly when I applied for SILK, I used the work that I'd done with the scholarships committee and so on. Can you take your examples from outside your actual practice area and use things where you've been involved in even non-law committees? If you're sitting on a board of governors for a school, for example, can you do things like that?
I mean, we haven't actually said the main competencies, leadership aside, are exercising judgment, possessing and building knowledge, working and communicating with others, and managing work efficiently. And yes, you can use what it is you're doing that demonstrates those skills. So you'll have the headline, you'll have bullet points underneath which tell you in relation to that particular job what's being looked for, and do the forensic analysis that Venetia has talked about. For me, I have to say, having done the SILKS application and having, as a commissioner, as an assigned commissioner on competitions, overseen, actually the time that I felt most hit home with me what was being looked for is I also sit on BTAS, which is a much smaller organisation that selects people for the bar disciplinary tribunals. And there, not only do we run the process, but we populate the process. So I actually have to sit down with people's applications and score them against the competency framework. And you're sat there thinking, you're telling me all this stuff, which probably means you do have the skills, but you haven't actually told me what you did. What did you bloody well do that demonstrated it, as opposed to telling me you're in a situation and people are responding to you and appointing you as if you've got the skills. And it's really that drilling down. What did you do? Yes, draw on your experience. And be creative. I remember the first time that I saw it as an assigned commissioner and thought, yes, this is exactly it. We are looking at transferable skills. Was when I was doing the Deputy Lord Advocates exercise. And, 80% of the applicants had never been anywhere near courts and litigation. They were in-field lawyers who were advising their seniors, so they weren't the actual decision makers about what was lawful and not on the battlefield. And so they're way there with pressure straight off, but describing how they're having to take the information, analyse it, apply it, and make decisions about what they're seeing as the priorities and the risks in order to give the advice, which was exactly your point. Within that, although you're not the ultimate decision maker necessarily, you will be making decisions, you will be exercising judgment about how you approach things and how you handle a situation. It may be in terms of judgments that you're making that lead to the advice, or judgments about how you actually navigate a situation and convey the messages you're wanting to convey, all sorts of things. So it's really digging down for your action, but yes, widely across your roles and what you're doing.
And that's, I think, probably encouraging for people who are at the start of their legal careers. They're at the start of their career at the bar. It's about thinking forward, what things can I do now at the start of my career that I can then build upon and use to make my application at a later stage.
Could I just add one point perhaps to what Brie said is this point about transferable skills is incredibly important. I hope the transferable skills matrix is still on the JAC website, but there used to be a transferable skills matrix. And I just want to make a point to you about employed barristers, which is that you're going to be competing with a lot of people who have come from a very different background. So the question you've got to ask yourself is, what is it about my skill set and my experience which makes me stand out? And I think if you ask yourself that question when you approach each competency, then things like your management experience, running a team of people or dealing with internal issues, all those things that people do as part of large organisations or as an employed barrister, either in the government legal service or a firm or in-house, all of those things make you stand out from members of the employed bar or indeed solicitors' firms who are applying. So there are lots of things that you do and which have given you the experience which makes you suitable for this role, which they don't have. So when you come down to face this application form, think about that. Think about what is it about my experience which will make me stand out to the people that, and obviously you won't have the skills of deciding cases, but what you will have is proxies for that kind of thing, either involved in things in the workplace, but what you will also have strongly is things like managing workload. Some of those competencies you can really score very highly on. And what you've got to say is that, well, there are ways in which I can overcome the lack of experience in the other competencies. And the other point I'd say is that what judicial consultants will tell you is that bad experiences are almost as good as good experiences. So if you've had a bad experience, case goes disastrously wrong, the judge is, disbelieves you. That's the kind of thing that you'll have if you're an independent barrister like I was. But bad experiences from which you have learned and then been able to implement that learning are always good things too. But then you probably think of them as disasters. But in fact, they are the kind of experiences which will help you to prepare for and discharge this role, because it's as much of this is acting under pressure when things go slightly wrong, when you get something comes out of left field and you've really got to deal with it. And it's those kind of abilities which you might have all the time in the workplace, which other people particularly if they're in chambers cocooned against the world by a clerk or by the kind of work they do, just won't have. So I think it's a combination of those things. Think about what what makes you stand out, which other people won't have. Think about the experiences that have made you better able to cope with the work that you do now, and think about the real strengths that you can put in to overcome some of the weaknesses in your application form. I think if you sit down and approach it those days, of course you've got lots of detailed advice. If you approach it like that, I think you at least begin to get a framework for the kind of application you want to make. And even if you think, gulp, at the end of it, God, this isn't going to work, take the Jonathan Brock advice, stick the application in. Who knows? You might be wrong. And if it doesn't work, come off this time. There's always next year.
Thank you, Tom. I'm going to hand over to questions from people who we have live in our audience. Sounds like X Factor. But also, we have a couple of questions from people who are online. And Brie, I'm just going to ask you firstly. We have a question saying that someone is working as a decision maker for the Home Office. They've been called to the bar, but they haven't completed pupillage. Studied the BBC, recently Master of Laws. Can they apply to be an immigration judge?
Off the top of my head, I don't think so if they haven't completed, pupillage.
Yeah.
But that, I know that's something that's come up recently and we've been looking at again. That particular candidate did then go away and in fact qualify.
Okay, so it's perhaps worth watching the JOC website,
yeah,
as everyone who wants to be applying will be doing now from this point on.
Indeed, and sending in a question, because when people have unusual situations, one thing I will say about the JAC, what I love most about it, of all the organisations I've worked in, been involved in, engaged with, it is the one that is the least defensive about how it can improve.
Yep.
Every single competition, we have a learning points list. We work our way as a commission through different parts of the process. We had 2 years looking at candidate experience constantly. How can we change that? How can we improve that? So actually, if there is something that's not fitting, send it in, send in that message, because those things get picked up. And if a few people are saying, hang on a minute, how is this working? Surely I should be someone you're thinking about. But then it feeds into the system and asking that question and looking at how we can make it work.
Really,
because we've had to do that around academics, for instance.
No, and I agree. Time moves on, as we discussed at the beginning of this. The traditional model that perhaps we all started out in our careers thinking of, judge, has now long gone, thankfully, and we are far more diverse, certainly as a profession, and certainly the judiciary is. So that's encouraging to hear. It's a thinking organisation.
And I would say we're still on the journey.
Yeah,
change is still to come.
Now, a question that also come from online, then I'll throw it open to floor. And this is something, I mean, I have applied previously and have been knocked back because it's these situational judgment tests at the beginning. They're an absolute nightmare. You have to read it all and then answer the questions in like a nanosecond. And someone has said that they've applied a few times for various roles, but struggled to get through either the online situational judgment test and the online scenario test. Sometimes got through to the second stage, but finding them very difficult. And they've spoken to various other people during the Page course who've had similar experiences, particularly around choosing the most relevant answer, because I think they're quite sort of tightly worded, must or may and things like that. Has anyone got any tips? Because you guys have all done these situational tests. Anyone, any tips on how to get through them? Because I have to say, I put my hand up and think, I don't want to apply because they're actually quite difficult to get.
Stressful.
I'd rather do a silk application than a JOC application, which says something, because that's horrendous. Just how do people in my position, same position as this person, how do we get through that?
I think keep doing them is one thing. I know in my chambers, and I told them, do not involve me in this at all. but there was a couple of years where a number of people were applying, and they were then talking them through afterwards. You know, some could remember some questions, etc. And I think people, through talking about them, actually started to get their heads around what was going on with them. What I would also say is that is actually something we're looking at again, because we're on a constant cycle of reviewing
Hang on a minute,
everything.
do we know how to go through all
No,
that?
no, I'm not saying they'll be abandoned. I'm not saying they're being abandoned at all. But, you know, we are on a constant cycle of looking at each element and all our tools, and we're looking at those at the moment.
That's really
They're
helpful to
being
know. Thank you.
investigated by external.
Then I might apply.
I think I'd add, if you're actually trying to do what a useful tip I was given was in advance, particularly in, I think the situational judgment one is one where you get most relevant, least relevant as court situations. Look at the overriding objective and the notes to it, because actually often what you're being asked to do is apply the overriding objective, essentially. And also have a quick look at the Equal Treatment Bench book, because it's available online and it's invaluable for loads of tips of how to deal with different situations that might come up, where you've got people of different cultures, different nationalities, different conditions and things. I found that actually looking at those sort of gave me a sense of, it sort of set my fairness down in a sense, in the right position, right frame of mind to be able to look at those sort of tests.
I think that's really helpful, and actually what Charlotte said as well about actually going to see a tribunal, going to see it and seeing what happens in one, you've got a better idea of putting it all into context. I'm going to ask if anyone here has any questions for our panel. I know we've got a couple of others that might be answered online, but hopefully we can do something about that after the panel this evening. Anyone, any questions? You're going to drive. Oh, thank you, Henry. I was going to do that and race around. I can do it. I can just get it. Lady at the front here. Sorry, here.
I just wanted to ask a little bit more about applying for a role which you have no legal experience in. So, for example, if you're coming from the CPS and you're applying for the tribunal, how would you demonstrate that you would be able to apply the law properly for that role? Is there anything else that you can do apart from going to the tribunal to watch?
You don't have to demonstrate that you can apply the law for that tribunal. The first chair tribunal fee paid competitions are across the board, they're non-jurisdictional. So the questions that you're being asked and what you're being asked to demonstrate is that you can possess and use and build knowledge. So you can pick it from whatever you know and your experience. When you get into the selection day, the role plays are non-jurisdictional. So to give an example, I can remember one which was, you're a manager in a hospital and there is a dispute about who's going to have a bed and on a ward and in a private room, and it had transgender in there as well. That's what you had to be role playing, making the decision about, and dealing with these two people making arguments for the two sides. So it's not about applying the law for the role that you are going for. First of all, fee paid, you won't be going for a particular tribunal. You'll have said what you're interested in, but it's non-jurisdictional. So you draw on your knowledge and experience to demonstrate how you are able to build knowledge, and then you're tested on something that is not requiring you to know the law. You'll be provided in the materials with a code or the rules, and you're being asked to use them in an example.
So it's about transferable skills, I think.
And you nothing, and you absolutely nothing until the first day I sat in the immigration tribunal about immigration law. Like nothing. That is the joy of it.
Yeah.
Is it because you don't have to know the law. It really is just testing the skill base. So
The training comes after.
Yeah, honestly, you don't. I said you reach a certain stage where you have to know the law, but that's the joy of the tribunal jobs. Yeah, it's great. We probably have the same interview. That say, it's just non-specific.
Yeah.
why it's really encourage people to apply for tribunals.
I knew nothing about benefits
go.
law at all until I was told that I was sitting in the social entitlement chamber. But the Judicial Training College is amazing. The training they give is second to none. So after 5 days of training in Newcastle, I at least felt I knew something before I had to sit.
The lady at the back here, and then gentleman in the middle, lady here, and lady at the front, and then I think we'll probably have to call it a day. I'm going to go over by 5
First of all, I'd like to thank you all for giving up your time this evening. I know you've got incredible levels of experience and a real breadth in terms of your practice. And one of the things I wondered as I listened to you, obviously this is a process that's changed very much over the years. And really it's a question for Tom, I think, because clearly you've had the experience of placing yourself well to reach a particular role and having a particular goal. And you've talked about being knocked back for silk and then applying for roles applicable to your criminal practice, and then really repositioning yourself by the sounds of it and finding yourself in the role that you've obviously got now. Was there any thought process in terms of, I must shift from here to here, and that way another avenue follows from it? Or is it such a different process now that it really doesn't matter what your experience is, and you just kind of throw the dart at the dartboard, and then, you know, it's a bit like the sorting hat at Harry Potter, you know, here you are and you think you're this, but we've looked at you and we think your skill set is over here. You're in Slytherins, actually.
I think in my case, there probably wasn't a great deal of thought. There was a lot of gloom after each unsuccessful application, thinking. I think I was very lucky in a sense to move from the independent bar to HSF, because that gave me an opportunity to reset. And I wasn't actually planning when I moved to apply for a judicial role at all. I thought, you know, the prospects of that were way behind me. And so my first point, which I really wanted to encourage everybody to think, is that even if you don't think it's for you now, there may come a point in time when it is exactly the right thing for you. And choosing the right time can be equally important. And I don't think it matters how old you are or when you take this on. There is a right time. There was a right time for me, and it came up rather late in life and later than I expected. And I think that's the first point. It may not be right for you now, but it may well be in a few years' time, change of circumstances. But the second thing is that once you make a decision to go for it, you've really got to commit to it, both in the process itself, and then if you get a fee-paid appointment and you're looking for a full-time appointment, through those three processes. And as I say, you've really got to, I discovered when I started sitting how much I enjoyed it. And as I said, found I enjoyed it far more than the day job, which is why I'm now sitting where I am. And I think it was a progression. And I think you often find that certainly in my life, things have sort of come out of left field, and things have gone a different way from the way I anticipated. And this is just like this. It's not, I think the bar, and this may be a good thing and a bad thing, both employed bar and the independent bar, can be a very unstructured place to practice. But there is that benefit, which means that when you feel the time is right, you can, and may I encourage you all, you should apply for these roles. You know, the judiciary needs people who are committed, you know, good lawyers who believe in fairness and the rule of law. We need people like you to come and apply for these jobs, and that's I suspect why all of us are sitting on this panel today.
Thank you. I'm going to take one more question from the floor because I've noticed time, Henrietta, but obviously all of our panel members will be outside for drinks in a moment. Can I just ask, we've got some questions online. Will they be able to be fed back to, I can see some of them are quite specific about,
So perhaps
can I apply?
answer some
Yeah.
of them online.
Perhaps Brie can answer some of those online if they can be forwarded on to our panel members. That would be really helpful. I'm going to ask, gentlemen, yes, thank you. And then, as I say, if you want to circulate afterwards, then I know all of our panel members will be staying because there's free drinks.
I'm employed by the CPS, and it's really the reverse question of the question that was asked earlier on. If you did want to use your experience as a criminal advocate or a criminal lawyer as well, how although there's not a complete bar, at what stage does the shutters come down in sitting as a district judge magistrate?
Well, it's the conflict issue.
Yes.
So, as described, the ability to go and take a fee-paid appointment elsewhere, which I would encourage people to do to find out if it is for them. And then when you're moving to a full-time appointment, obviously the conflict evaporates, apart from anything historic that you've had direct dealing with.
Two people who started with me did that. They both, a guy called John Bristow in the Midlands and a woman called Hina Rai in London. We all started, we're all ex-CPS, we all started at the Immigration Tribunal, and they both applied and got, after 18 months in immigration, a full-time Mags Court position because they demonstrated that they had judicial experience. And so that's how they just crossed straight over. And that's how they did it.
And I think it's the same with you, Charlotte. You went into full-time immigration, but you're now sitting as a Crown Court recorder, which you couldn't have done if you were still in the CPS. But you can now do it because you're outside that position. It would be the same for me if I was applying something, again, using opportunities creatively. Think about things like going down the coroner route as well, because you can sit as a coroner and you can apply. So that might be something else. But
can I just sell my tribunal to all the people who do crime? Can I say, everyone who's come from the criminal jurisdiction who's gone to the Immigration Tribunal, with almost that exception, has really enjoyed it, because actually there's a lot of similarities. There's a lot of credibility issues, applying the facts to the law. It's a forum that's very similar to the Mags Court, so actually it doesn't feel alien. There's writing is like writing judgments. It's all pretty much all written judgments. Is like writing a charging decision. You know, you have to explain your reasoning and set out your decision. It's a really, really comfortable area, even though it sounds crazy because the law is completely different. Skill-wise, it's a really comfortable area for criminal practitioners to work in. And we have a lot of fee-paid judges who are criminal practitioners who sit in our chamber. So I'd really encourage it. It's a way for CPS people to get around that really intractable problem. It's never going to go away. It's really difficult to sit as a deputy DJ.
Thank you, Charlotte.
Can I just say about pathways that increasingly people are moving, you've already heard some of it, between tribunals and courts. And the point was just made that you can have a full-time appointment and still have a fee-paid appointment in another jurisdiction. So there are increasing numbers of people who go in at one level, fee-paid, either put together a portfolio of fee-paid or then move into salaried and move and work their way, either because they're interested in different things and want to do different jobs, or because they have a destination in mind.
No, that's really helpful. And I think that comes back to the point that we said at the beginning, think creatively and actually be brave about doing something that might seem a bit outside your comfort zone to start with, because the positive experiences, particularly what you've just said, Charlotte, you know, going into something. I remember your first day, we met you afterwards, where you came with a suitcase full of immigration books, and it was,
which I've never read.
I
still haven't read.
Every time Charlotte says that, I should
haven't
just
read.
cover Brie's ears. But you know, you now love that job, and I know of it. And I think it's just about thinking about your transferable skills, starting early on and looking at what the competencies are on the Judicial Appointments Commission website, and starting to make a little sort of ready reckoner on your laptop about things that you do, you know, that you might not remember 3 years down the line. You go, oh God, I did this amazing thing and I can't remember what it was. Just create a file on your laptop. And you know, I don't know whether you did it, I did it for Silk, you know, and then 3 years down the line, you're going, oh, that went into competency so-and-so. Just building that, especially if you're at the beginning of your career. So it's think creative, use those transferable skills. And let's get more employed barristers on the bench. And thank you very much, all of you. Really, really appreciate your time this evening. And thank you again to Henrietta for organising this. Can I just ask for a round of applause? And there are drinks.